marking the 50th anniversary of the 1967 war, in which this Center for Middle Eastern Studies, as well as the Center at UC Santa Barbara and UCLA, are jointly each creating panels to address this milestone through the meta-narrative of 6 days, 50 years, 1967, and the politics of time. UCLA is addressing the past in very interesting ways. UC Santa Barbara, the present, and frankly, as I said this morning, always being sort of in the vanguard. We are addressing the future. We've envisioned this gathering as an opportunity to think creatively and collectively about the question of how horizons of the future were differently produced after 1967 across different disciplines and specializations, and we had a wonderful panel reflecting precisely that this morning. Now we are pleased to have our keynote address, and I thank all of you who made it today, even though we had originally scheduled it for last night, but given all the tumult on the campus last night, we thought we'd better do it today. And we're also very grateful to our keynote speaker for rearranging her program to join us this afternoon. Noura Erakat is a human rights attorney and activist. She's an assistant professor at George Mason University, whose research interests include the laws of war, human rights law, refugee law, national security law, social justice, Palestine and the Palestinian-Israeli conflict, and the Middle East in general. She's a co-founder and editor of the well-known Jadidiyya e-Zine and an editorial committee member of the Journal of Palestine Studies. Prior to joining GMU's faculty, she was a Friedman Teaching Fellow at Temple Law School and has taught international human rights law in the Middle East at Georgetown University since 2009. She served as legal counsel for a congressional subcommittee in the House of Representatives, chaired by Congressman Dennis Kucinich. Her scholarly publications include U.S. versus ICRC Customary International Humanitarian Law in Universal Jurisdiction in the Denver Journal of International Law and Policy, New Imminence in the Time of Obama, the Impact of Targeted Killings on the Law of Self-Defense in the Arizona Law Review, and Overlapping Refugee Legal Regimes, Closing the Protection Gap During Secondary Forced Displacement in the Oxford Journal of International Refugee Law, a very noteworthy and impressive, I'd say, bibliography. Noura's media appearances include CNN, MSNBC, Fox News, PBS NewsHour, BBC World Service, NPR, Democracy Now! And Al Jazeera. She has published in The Nation, The New York Times, the Los Angeles Review of Books, Huffington Post, The Hill, and Foreign Policy, among many others. She's also the co-editor of Aborted State, the UN Initiative and the New Palestinian Junctures, an anthology related to the 2011 and 2012 Palestinian bids for statehood at the UN. Most recently, Noura released a pedagogical project on the Gaza Strip and Palestine. The centerpiece of the project is a short multimedia documentary, Gaza in Context, that rehabilitates Israel's wars on Gaza within a settler colonial framework. She's also the producer of the short video, Black Palestinian Solidarity. Noura is currently working on a book project tentatively titled Law as Politics in the Palestinian-Israel Conflict. We are delighted to have her here with us today to give this keynote.
Thank you. Thank you, Emily. Thank you, Julia. Thank you, Neil, who's not here, but I think Neil deserves the biggest thank you. He was taking care of logistics and he had to put up with me. So thank you so much. I'm very excited to be participating in today's events because they're taking place across the UC campuses, as Emily mentioned, here at UCLA, at UC Santa Barbara, and we're using the occasion of 5 decades of occupation, which is an oxymoron, really. You can't have an occupation for 5 decades, but anyway, we'll get to that, to reflect on how 1967 as a juncture has impacted various fields, but also to reflect on how the occupation itself functions as a structure. I'm particularly excited because we're in Berkeley, where I experienced my most formative education as an undergraduate student, where I frequented this center many, many times. Also as a graduate student at the law school, and of course, I think most significantly as a student activist, where I think I learned the most about politics and power and social justice. I have the privilege and the fortune to be marking my return here, to be speaking to all of you today, to be sharing a piece of my book project. The book, which is tentatively titled Law as Politics in the Palestinian-Israel Conflict. I'm thinking of something like Violent Order, or something really gruesome. But anyways, the book itself seeks to narrate a history of the present through critical engagements with international law, or perhaps put more memorably, what if the law could talk? And kind of as a nod to hip-hop and popular culture, think about it this way: if these laws could talk. Okay. In all seriousness, but really, if you're thinking about this and thinking about what the book is doing, I think it's important to go back and think, if the laws could talk, what story would they be telling? How would it shape our understanding of the Palestinian-Israel conflict differently? How would we understand the present condition not as an outlier of systematic violation, but instead as a structure in and of itself that functions as a model of what international will look like into the future, not as just a bump not just as a failure that we're experiencing. So foregrounding the law as a narrator helps to answer some of the most vexing questions, at least for me. For example, how has an exorbitant register of death and destruction as experienced in the Gaza Strip during Israel's most recent military offensives become tolerable in the language of law? Why and how has the two-state solution become dead letter as a function of the law? And what role did it have to play? How has the Palestinian use of force been delegitimized to the point of extinguishing armed resistance by criminalizing all of it? And why has occupation law failed to regulate Israel's occupation of the Palestinian territories? As we know, occupation law prohibits the civilian settlement, the transfer of a civilian population into occupied territory, the removal of a native population from their territory. Yet today, there are nearly 600,000 Israeli civilian settlers in the territory. The territory is cut up into more than 12 discontiguous land masses, and the number of settlers exceeds the number of settlers in 1993 by approximately 300%. But compared to 1976, the number of settlers has increased by 4,000%. So, notwithstanding that, Israel has endured little to no legal accountability for entrenching its settler colonial enterprise, despite an international consensus, including the United States, that civilian settlement in the occupied territory violates occupation law. So what explains that? How do we explain that conundrum? And today, that is the chapter that I'm sharing with you, one that scrutinizes the 1967 war as the moment of establishing a legal political machinery that has enabled Israel to incrementally and steadily take the land without the people on it. The machinery itself is a continuation of a legal regime that was established and implemented between 1948 to 1966, as we heard this morning from Lina Delashe, thinking about how the martial law regime, by acting as exception, was also acting as a structure in order to confiscate and accrue the land, also by removing the population. In the territories, how this happened is that Israel strategically deployed occupation law to incrementally take the land without the people, and has applied UN Security Council Resolution 242 to retroactively legitimate those colonial takings in a political framework that has been shaped by US intervention. Severally, these different pieces, occupation law, UN Security Council 242, and US intervention and counterproductive intervention in the region, have been exhausted in the legal, the historical, and the political science literatures. What I'm attempting to do here is to examine them not as different sums of a whole, but actually what they do when they're working together. How are they part of a reinforcing whole? In looking at them in that way, I'm examining the relationship between law and power, and specifically the ways in which the balance of power bears upon the meaning and significance of law during international conflict. So put another way, to think about it another way, Israel is not the first to deny the applicability, the de jure applicability of occupation law to its occupation. Yet, it's significant because it's been so successful. So what explains its success and actually not having to apply occupation law in a de jure way? And so ultimately, my explanation is that the failure of the law to regulate the occupation of the territories reflects the outcome of a political contest. Israel's legal argumentation would have no value but for the power politics that continue to shape international relations regarding the Middle East. So, to demonstrate how this is all working together, I'll start by briefly discussing the legal regime imposed between 48 and 66. Second, I'll turn to the 1967 war and specifically the drafting history of Security Council Resolution 242. Then I'll turn my attention to the logic of how Israel has rebuffed the application of occupation law, and specifically the Fourth Geneva Convention. I'll then turn to show how the U.S.'s dual policy, its dual commitment to ensuring Israel's qualitative military edge in the region, together with a commitment to establish peace or a permanent peace through a land for peace framework, has facilitated and retooled Security Council Resolution 242 to do the work that it's been doing. And then I'll conclude by thinking about the present and the future. So what does that mean for us in the present and the future? So, starting in 1948, just very briefly, the first act of Israel's government following its establishment was the adoption of the Defense Emergency Regulations, or the emergency laws imposed by the British colonial regime during the Mandate. Of the 162 regulations that the British imposed, Israel struck only those sections that restricted Jewish immigration and land purchases. And then it then applied these emergency regulations onto the Palestinians who remained within the state, who weren't yet granted citizenship, not until 1952. This was never about security, again, as we've discussed this morning, and what Shira Robinson shows us in Citizen Strangers. David Ben-Gurion plainly explained, quote, "The military regime came into existence to protect the right of Jewish settlement in all parts of the state." Within Israel. So the absentee property law of 1950 targeted the lands of Palestinians who had fled across the border and become refugees, as well as those who were internally displaced. The law naturalized the removal of the native population and confiscated that land without compensation to the owners. Using a similar tactic, military commanders used their emergency powers to declare lands closed areas at their discretion. The edict arbitrarily prevented Palestinians from cultivating their agricultural lands, rendering those lands wastelands. Under another emergency regulation, the cultivation of wastelands, it was able to then declare those wastelands. In 1953, the government passed the land acquisition law that retroactively legalized these land expropriations. In 1960, Israel enacted legislation that prohibited Palestinians from owning, leasing, or working on 97% of state-held lands. Together, these regulations, with a series of other land laws, work to dispossess Palestinians, refugees, as well as those who remain within the state of their homes, their businesses, and approximately 2 million dunams of cultivable land, so that by 1950, 72% of Israel's state lands were Arab-owned, and by 1953, Israel established 350 of its 370 new Jewish settlements on land owned by Palestinians. Israel ended its racialized martial regime against Palestinians in 1966, but then applied it on another set of Palestinians. And that's the population that we're thinking about today. But it's significant to start in 48 because the continuity of establishing a legal regime based on exceptionalism. The exceptionalism, obviously, is the state of security that Israel needs needs to suspend civil law in order to maintain order, obviously that's happening as a veneer of security, when in fact it functions as a settler colonial mechanism for removal, concentration, and displacement. So what's happening in 1967, and how did these logics of exception also transfer? By the close of the 1967 war, Israel's jurisdiction stretched across the Egyptian peninsula, Sinai, the Syrian Golan Heights, as well as the West Bank and the Gaza Strip, under Jordanian and Egyptian trusteeship, respectively. This morning we heard about the religious establishment being fervently in favor of keeping those lands, but actually across the board, 90% of the Israeli population supported retention of the territories. So never seeing it as the occupation of another's land, but instead viewing it as the liberation of the rest of Israeli lands, as somehow a miracle of liberating these lands that hadn't been liberated or conquered in 1948. But Israel couldn't just keep these territories. It had several obstacles. One of those obstacles is it's illegal. It was illegal by 1967 to conquer land and to annex it. And that prescription was enshrined in the first 2 articles of the UN Charter, as well as in the 1960 UN Declaration on Granting Colonized Peoples Independence and Freedom, as well as the respect of the territorial integrity of all states, and further enshrined in the 4th Geneva Conventions, which were created by different states in the aftermath of the atrocities of World War II, and the Third Reich occupation regime, which was not regulated and used the war as a cover for further colonization. So although there's an argument that all the world has been conquered, what makes Israel different, you're obviously singling out, well, in truth, it's just the timing was bad. And by 1967, it was no longer legal, and it was no longer acceptable as a matter of politically acceptable to conquer land in that way, similar to the way that slavery was legal. But you can't do it today. It's not legal and it's not acceptable. So that was one challenge. The second challenge, not that anybody really wants to do that. The second challenge is world opinion. There was an acknowledgement that this was a crisis, and that to solve this crisis, both Israel and the Arab states had to be satisfied. And so world opinion was against Israel's retention of those territories. So that was the second challenge. And the third challenge was the Palestinians themselves. Even if annexation was legal, or even if Israel would have been willing to take the risk of annexation as it did in East Jerusalem in June 1967, it did not want to do that because absorbing these Palestinians in the territories would disrupt its Jewish demographic majority. So now you have these challenges. It wants this land. It can't just take it because the law says it can't. And even if the law says that it could, it doesn't necessarily want it because it would have to extend its civil jurisdiction over these Palestinians. What is Israel to do? Now the challenge of world opinion was also what Israel was facing, was actually at the United Nations. At the United Nations, the global community had gathered. This was an emergency. They were deliberating this issue of what to do with this occupation, both in the Security Council and in the General Assembly. The debate within the United Nations revolved around 2 main issues. One was, if the international community described this as Israel's aggression, if Israel fought the war as an aggressive war, and in international law you can't fight a war unless you're using that force, or not war, you can't use force unless it's used in self-defense. Now you can use that preventively, there's some arguments under customary law, but that under the UN Charter law, there has to be an armed attack that then triggers the use of armed force in response. So if Israel, and here Israel uses force against Egypt and destroys its entire air arsenal within the first 2 hours without Egypt firing a shot. So if the Arab world, together with the Soviet Union and the non-aligned movement, is able to convince the rest of the states that this was an aggressive war, Israel would have to, by legal fiat, to withdraw from the territories. There's no discussion to be had. If instead this was a defensive war, and Israel then retained the territories in a defensive war, it doesn't give them the right to keep the territory, but it does give them greater wiggle room in order to retain the territory as consideration in a contractual agreement for permanent peace. Israel's two most strident allies in this regard were the United States and the United Kingdom, who wanted Israel to be able to retain the territories as consideration, but did not support territorial aggrandizement, as we'll see. At the time, the Lyndon B. Johnson administration is moved by several things. One, and Joel discussed this morning as well, is Johnson's own commitment to Zionism and what it means to him and his own reaction. Didn't accept it because it didn't like that it was mandating withdrawal from all the territories, but the U.S. actually voted for it, which indicates the support for the principle of withdrawal from all the territories. Further, what tells us more about the drafting of this, and for those of you who are familiar with the law, we go back to understand what the law is saying on its face by understanding what the intent was. So in June 1967, when it became clear that Israel wanted to annex East Jerusalem, the British foreign minister explained that if they do so, they will, quote, be taking a step which will not only isolate them from world opinion, but will also lose them any sympathy that they have. And that a peace agreement must be based on Article 2 of the UN Charter, which prohibits the use of force and preserves the territorial integrity of other states. He explains, quote, "Here the words, territorial integrity, have a direct bearing on the question of withdrawal, on which much has been said in previous speeches. I see no two ways about this, and I can state our position very clearly. In my view, it follows from the words in the Charter that war should not lead to territorial aggrandizement." Again, the Johnson administration was in agreement with this. It didn't want to specify withdrawal from the exact territories because it wanted to leave room for minor modification of the borders in order to have what Johnson himself considered only fragile and violated truce lines, and here he's referencing the 1949 armistice lines. He also, President Johnson also trusted repeated Israeli assurances that it would withdraw from the territories in exchange for peace. And it was upon that firm basis that the U.S. Was such a staunch supporter of Israel during these UN deliberations. Even when Johnson had indication that Israel wanted to retain the territories, he believed, quote, that Israel would become more moderate and flexible once the euphoria of victory had worn off. When Israel annexed East Jerusalem in full daylight on June 28, 1967, the General Assembly unanimously passed two resolutions. The UK supported, the US abstained, and both countries refused to remove their embassy from Tel Aviv to Jerusalem. Today, although we got an indication that Trump has also said that they're not moving the embassy, we'll see why it actually works better in Israel's favor to maintain this steady encroachment rather than do something so radical as to break with that status quo. In any case, in order to break the deadlock within the United Nations, the UK introduces this draft resolution. This is draft resolution 242. And here I want to point out just a few things to you that I've highlighted in bold. The first is the preambular text, which emphasizes the non-admissibility of territory by force. But in law and in a resolution, the preambular text is not as binding as the text that follows the command. Okay, so that's one. The second is that here it says withdrawal of Israeli armed forces from territories occupied in the recent conflict. If you notice, there's a word missing. If you compare it to the first clause here, and this clause here, you see the word that's missing is all. The and all is missing, which indicates a lack of specificity, which is quite significant for any of you who study the law or are lawyers, quite significant in law, at least for the amount of wiggle room that it provides. And then lastly, I want to point this out, that here we have the only passing kind of reference, almost passive reference, to Palestinians as a mere refugee problem. and no indication here you're going to establish, this was to establish Israel's presence in the Middle East, but no quid pro quo that would also establish and ensure that Palestinians would be able to enjoy the same type of juridical de jure presence as a matter of self-determination. This now, because of this, there is actually debate within the Security Council, robust debate about the missing definite article all. But state after state that is voting for the resolution is emphasizing, and here's what the French ambassador is emphasizing, they're all emphasizing that even if the definite article is missing, we are taking what the British have said, what the foreign minister has said, for it to mean withdrawal from all of the territories, together with the preambular text. Mali and Nigeria, together with India, also proposed a resolution, and India's comment was to say that its delegation has, quote, studied the UK draft resolution in light of these two policy statements of the British Foreign Secretary. It is our understanding that the draft resolution, if approved by the Council, will commit to the application of the principle of total withdrawal of Israel forces from the territories. I repeat, all territories occupied by Israel as a result of the conflict which began on June 5th, 1967. Now, Israel, who is represented by Abba Iban during this time, is very forthright about what they think this means. Because what Israel wanted was to have no resolution at all, which would have given it as much room as possible to do what it wanted with the territories. And if there was a resolution that was going to pass, they wanted the resolution to be as... They wanted it to be as least restrictive, thank you, Leah. They wanted it to be as least restrictive as possible. So when Israel is listening to the debate, their response in the UN is to say, quote, for us, this is Abba Iban, for us the resolution says what it says. It does not say that which it has specifically and consciously avoided saying. Okay, spoken like a true lawyer. That Israel sought to use the ambiguity of this language in order to fulfill its territorial ambitions was not lost on all of the states. Syria, in particular, was vehemently opposed to it and thought that actually passing this resolution would reward Israel for what it considered its aggression and show nothing in return for Palestinians. For their part, Nasser is Egypt, and Exins, Jordan, both vote in favor of the resolution because they feel that despite the missing definite article that the resolution would have force, they also felt that Israel was there to stay. And so despite the decision that they had made in Khartoum in September 1967, just a couple of months before this vote was taken, where they adopted a position of no reconciliation, no recognition, no negotiation, they both voted for the resolution. The resolution passes in November 1967 by unanimous vote. This is, for Palestinians, very obviously and very tragically a failure. And Walid Khalid, the historian who represented Palestine through the Iraqi delegation at the time, explains that the dictates of power were already displayed. What the resolution did was give Israel, quote, a free hand and allowed it to dictate the terms of withdrawal at the pace that it wanted. It made the fate of the occupied territories, whether the Golan Heights or the West Bank, a hostage to the balance of power. The PLO could not accept it because it even allowed for the occupation of Jerusalem. After its passage, we clung to the preamble that prohibited the acquisition of territories like a drowning person. We clung onto it and exaggerated that. And Palestinian insight has proven correct. So now Israel has gotten around the legal mandate to have to forcibly or to withdraw as part of a legal obligation from the territories. It still has the challenge, well, what do you do with the population? And what do you do if occupation law, if these territories are occupied, what do you do with the prohibition on the actual taking of the land? So occupation law is meant to be temporary, as Madar pointed out to us this morning, is meant to be temporary. And it's meant to facilitate a transition from hostilities to return to the status quo ante established during peacetime, right? So what that means is that the occupying power has an obligation and a duty to to maintain the status quo, to maintain the territorial status quo, the geographic status quo, the status quo of the population itself, the laws that were in place, the natural resources that were in place. You cannot move any of it around, and you have a duty to protect that population. That's not going to help Israel at all fulfill its ambition. So how is it going to get around this? In 1967, during the deliberations at the Security Council, the Prime Minister at the time, Levi Eshkol, asks legal advisor Theodore Meron to comment. Well, and here's where we begin to see the beginning of this legal argument. Is civilian settlement in the territories prohibited, given that those territories weren't necessarily under the sovereignty of Jordan or Egypt? So if they weren't under the sovereignty, then how can you occupy a non-sovereign? In a top-secret legal memo, Meron concludes unequivocally, and this secret memo was only released in the past few years, says Article 49 categorically prohibits civilian settlement in the occupied territories. He also pointed out, as we've heard earlier, that Israel itself has a number of contradictions that have indicated that it believes the territories are occupied, most notably by Military Proclamation No. 3, which instructed the military to apply occupation law in the case of a conflict of law. And finally, the legal advisor reminded Eshkol that international policy rebuffed those territorial ambitions and would leave Israel with no allies. But Meron's findings, rather than stem Israel's ambitions and prevent it from moving further, actually gave it a way out. Specifically, Meron advised that if Israel wanted to build settlements, it should do so, quote, in the framework of camps, military camps, is on the face of it a temporary rather than a permanent nature. So heeding that advice, Eshkol instructed the army to establish paramilitary outposts to create the veneer of temporariness, and when settlers arrived at the settlement at the end of September, note, before the resolution passes in November, the state publicly referred to them as soldiers despite their civilian status. So this gave Israel the appearance of being law-abiding, despite the fact that it was actually violating the law in order to incrementally begin expanding its ambitions. In 1968, an Israeli law professor by the name of Yehuda Zvi Blum expands and articulates this argument in an Israel law review. And this is really important because in international law, what legal scholars' rights are actually constitutive of what becomes customary law. And Yehuda Zvi Blum articulates this argument about the missing reversioner to demonstrate that Jordan was not a sovereign in the West Bank. Doesn't discuss the Gaza Strip, but no, unlike Jordan, Egypt doesn't claim that the territory belongs to it. Jordan tried to annex the territory in 1949 and tried to claim that it belonged to it. And so Blum demonstrates that that legal title is not valid and that nobody can demonstrate better legal title than Israel. What does that mean? What does that mean in law? It means that Israel has no legal obligation to apply occupation law as a matter of law. Instead, it can apply the humanitarian provisions of it that are meant to protect the civilians, but none of its provisions that are meant to protect the national rights of the population or the sovereign rights that belong to them therein. And that's going to be quite significant, because then you're still applying the law, but you don't have to apply the law that's going to hamper your territorial ambitions, specifically those prohibiting civilian settlements. Why is this argument basically silly? I mean, I have a lot of expletives on the tip of my tongue to describe this argument, but we're in an academic setting, so why does this argument not withstand scrutiny? For several reasons as a matter of law. One is, and most significantly, Blum never considers that sovereignty vested in the Palestinian people themselves. So only considered that sovereignty would vest in the state of Jordan, but never in the Palestinian people themselves, in a way that belies the empirical evidence that we have that establishes that Palestinians are a people in the juridical sense. Specifically, Article 22.4 of the League of Nations mandate recognized the provisional independence of Palestine in 1919. And Palestinians under Ottoman rule had an effective system that was tantamount to statehood, which is why they get categorized as an A mandate as opposed to a C mandate, which meant that it was going to be provisionally recognized as independent. The only reason that Palestinians don't come to enjoy that independence like their counterparts in Iraq and Transjordan and elsewhere is not because they didn't have necessarily that right of knowledge, but because the British had promised to establish a Jewish national home therein, and so delayed and never fulfilled the promise of Palestinian independence. And although self-determination was not a customary right in 1949, Palestinian self-determination itself had been reiterated across time and space in the mandatory system in 1919, in the Peel Partition Plan in 1937, in the White Paper in 1939, in the UN Partition Plan in 1947, as well as the UN Draft Trusteeship Agreement in 1948. Even David Ben-Gurion explains, who ultimately ordered the removal of Palestinians, also recognized this, and says, quote, that the right of self-determination is not limited and cannot be qualified by our own interests. It is possible that the realization of the aspirations of the Palestinian Arabs will create serious difficulties for us, but this is not a reason to deny their rights. Therefore, when the British mandate expired in May 1948, sovereignty vested in the people of Palestine. Arguing otherwise would make the territory vulnerable to conquest by whoever could invade first, and thus contradict the whole reasoning behind the mandate system. To argue that Palestinians, as Israel continues to do, are merely a polity of Arabs and Bedouins from surrounding Arab states and not people belies this history. The second legal argument and rebuttal to this is that high contracting parties, the Geneva Convention binds high contracting parties and not states, which are the same thing in this case. But here's why this is important. The drafters of the convention were aware of attempts made by invading armies to do specifically this, historically, to negate a territory's sovereignty to justify their conquest. They, in their drafting, deliberately aimed to close that loophole in the drafting process so that the conventions could apply in, quote, all circumstances, regardless of a territory's status. Because Jordan, Egypt, and Israel were all high contracting parties at the time, that meant that this was a circumstance in which the convention would apply. Thirdly, Blum was making an argument for defensible acquisition, that if it was a defensive war that you can acquire the territory, but the short answer to that is that that has no basis whatsoever in international law, whatsoever. The other thing to think about that was just really clear, that just made it clear that Israel was engaged in its own contradictions. Israel doesn't apply occupation law to the Egyptian Sinai or to the Golan Heights. And there, the sovereignty is not contested. Syria, the statehood sovereignty of Egypt and Syria was not contested. They didn't apply it there either. But the desire for settlement wasn't as pressing as it is in the West Bank and the Gaza Strip. So, this is the argument that Israel makes. And in fact, there is no legal basis for the argument. Since its articulation, the UN Security Council, the UN General Assembly, the International Court of Justice, the International Committee for the Red Cross, as well as several international human rights organizations, almost all of the ones that you can think of, have rebuffed Israel's legal arguments and repeatedly affirmed the applicability of the Fourth Geneva Convention to the West Bank and the Gaza Strip. So if the legal argument doesn't withstand scrutiny, and there's an international consensus against it, including from the United States, then how is Israel able to continue its civilian settlement notwithstanding that opposition? And so here the answer is mainly through U.S. enablement. Mainly through U.S. enablement. Igal Alon, who is the Israeli deputy minister during the Six-Day War, developed a doctrine of defensible borders to justify its settlement expansion. And so I won't explain those defensible borders to you, I'll just show you. So here's the Alon plan. The idea is that they would protect the border, the easternmost border with Jordan. They would create a transit between the coast, the Mediterranean coast, and the Jordan River, and they would create this seamlessness of the continuity of Israeli jurisdiction over Jerusalem. Okay, this amounted to, as you can see, this amounted to almost all of the West Bank and the Gaza Strip, and adherence to them would ipso facto undermine the return of land for peace. And assuming just for a second, just for the sake of argument, that in fact these defensible borders are necessary for security reasons, the fact that Israel is settling its civilians to ensure that security is violating the law in two ways. One, it's suggesting permanency, and two, it's using its civilians as human shields, which is, as Israel has reminded us many times, a violation of humanitarian law. So then, how is Israel then effectively deploying this security framework? Here's how it's doing it, and here's just one anecdote. In July 1977, Prime Minister Begin was visiting US President Jimmy Carter in the United States. Upon return to Israel, confers legal status on 3 settlements, so now makes them permanent. The US's Carter administration immediately expresses disapproval and disappointment and says, quote, "The establishment of settlements in the occupied territories is not only contrary to the 4th Geneva Convention, but also constitutes an obstacle to progress in the peacemaking process." So very unequivocally, this is a violation of law and policy. In response, Begin delivered an address to his Knesset denouncing the US's charge and adds, quote, "Jewish settlement does not in any way or under any circumstances do harm to the Arabs of Eretz Yisrael. We have not dispossessed and will not dispossess any Arabs from his land." All right, so using the veneer of occupation law and the fiction of temporariness, Begin justified the presence of settlements as a temporary measure and thus not a seizure of lands. And rather than combat these maneuvers as altogether illegitimate, engagement in the narrow legal inquiry. So is this in violation of occupation law? Is it not in violation? Is it temporary? Is it permanent? By engaging in that discourse that doesn't altogether declare it illegitimate, what we end up doing is losing the forests in the face of a single tree. In fact, in a press conference 2 days after Begin's remarks to President Carter, Carter goes as far to almost perpetuate Israel's argument and says that, yes, the settlements are an obstacle to peace, but they are not an insurmountable problem. He goes on to say that, quote, "The Israeli government has never claimed that these settlements are permanent. What they have done is to say that they are not legal at the present time." Okay, so what's going on here is that the legal fiction of temporariness and military function allowed Israel to steadily poach these Palestinian lands. It then deployed Resolution 242 to justify its expansions into the territory as just necessary for defensible borders as mandated by 242, and what the US and the UK saw as necessary to modify those final borders and the final status agreements. Because if Jordan or Palestinians voluntarily cede the territories in a peace agreement and exchange that land for peace, then Israel didn't take the land. Israel established peace in exchange for the land. And so that you could ostensibly then take up to 62% of the land and still be in compliance with the language of 242 and occupation law within this legal political machinery. So obviously, if we look at the drafting history, that drafting history unravels Israel's legal acrobatics, but law, and especially international law, is only as meaningful as the political will underpinning its enforcement. And the United States, its provision of unequivocal military, diplomatic, and economic aid has impeded any such meaningful actions. Still, and despite its seeming allegiance to Israel within the Security Council, U.S. administrations, beginning with Lyndon B. Johnson in 1967, to the present, well, we'll see to the present, have insisted that Israel withdraw from all the territories with minor border adjustments. And so, At the time, and we know this at the time because the Johnson administration felt particularly obligated to its ally King Hassan of Jordan and repeatedly pressured Israel into entering into talks with him for return for the West Bank. The Johnson administration promised the king that he would regain the territory in a matter of 6 months, despite the fact that Israel had no such intent. But because Israel became exclusively dependent on U.S. military aid after the war, it couldn't just outrightly rebuff those entreaties and instead engaged in what historian Avi Raz has described as a foreign policy of deception, namely a series of cabinet resolutions and ad hoc government decisions and actions that added up to a consistent policy of deception, the aim of which was to mislead the international community, first and foremost the U.S., into thinking that Israel was seriously seeking a peaceful settlement with its Arab neighbors. Immediately following the war and for several years thereafter, King Hassan made repeated overtures that Abba Iban describes, he engaged in them and describes what they were as futile discussions. What Iban did was to, quote, insert a sufficient number of obstacles into any American document about an Arab-Israeli settlement so that Arabs could not accept it. It had a much easier time to rebuff the same overtures that were coming from Palestinians who were organizing themselves because there was no official acceptance of Resolution 242 by Palestinians. In 1969, when it became obvious, the ambitions to keep the West Bank and the Gaza Strip, when Israel's ambitions became clear to the U.S., and the U.S. asked, we promised to return these territories, Aban, according to Eugene Rastow, who was in the State Department at the time and who is an avid supporter of Israel's legal argument, explains that Aban shrugged his shoulders and says, we changed our minds. The Johnson administration did not take this lightly, but at the time it was constrained by its deep involvement in the Vietnam War. It did not have the capacity to turn its full attention to the Middle East. Together with Johnson's personal commitment to Israel, the Soviet Union's mounting penetration in the region, and the rise of Palestinian guerrilla attacks, the U.S. did little more than issue a series of empty condemnations and frustrated diplomatic cables. In the 5 decades since then, because now we're commemorating 5 decades of this, so in the 5 decades since then, the U.S. has tried to leverage its patronage to shape Israel's behavior, but in those instances where an administration has been willing to impose meaningful pressure on Israel, it's been unable to do so because of congressional opposition. Congress's susceptibility to special interest lobbying has made it a formidable obstacle to the executive branch to regulate Israeli behavior, and as a result, no U.S. administration has been fully able or fully willing to stem this outcome. So what does this outcome then look like today? If you look at this map of what the territories look like, and this is 2012, it's actually even more fragmented now. But if you juxtapose the map of the reality today against the Allon Plan, Israel has exceeded its own ambitions in the territory. And so one would say occupation law has been a failure, but in fact occupation law has been quite successful in facilitating this expansion in the framework of using 242 as well as the U.S. How can we, I think what helps to demonstrate that is to think about, and here you see a clearer picture, but to think about in February 2017 of this year, the Israeli Knesset passes something known as the regularization law, which seeks to basically regularize the status of Israel's 54 outposts, which are not, aren't official settlements, okay? And they passed this law to retroactively legitimate the taking, the expropriation of private Palestinian lands. And the world goes crazy. As you can see, if you remember, there was about 2 days of absolute outrage. The Israel center and center-right political establishment condemned the legislation. Netanyahu condemned the legislation. Germany canceled a high-level meeting with the Israeli government in protest. Britain, Turkey, Jordan, and France condemned the law. The UN Secretary General described it as a violation of international law, and the Mideast envoy said it, quote, opens the floodgate to potential annexation of the West Bank. In the same 2-week period that the regularization law was announced, Israel announced that it would build 6,000 new settler housing units in the West Bank and East Jerusalem. The regularization law would have regularized 4,000 housing units. This new announcement sought to build 6,000 new housing units. This protest, the regularization law, was absolutely absent in response to the second announcement. What explains that? This was about 30% more settlement units that were going to be built, and yet less protest than in response to this law. And the reason for that is that the regularization law broke with Israel's own internal logic, and thus threatens to unravel the legal and political machinery that's enabled it to steadily and incrementally achieve its territorial ambitions. Unlike Menachem Begin and Meir Shamgar, who insisted that there was no dispossession or threat of annexation, the regularization law is established upon the assumption that there is no occupation at all. And here this becomes really critical because there's a very thin line between the idea of a sui generis occupation, or this not normal occupation that Blum and Shamgar argued existed, that because there's no sovereign, it's an occupation, not really, so we only apply the humanitarian provisions, and no occupation at all. That the line that divides them is very thin. Strict adherence to occupation law today, therefore, if we continue to just insist, apply occupation law, apply occupation law, apply occupation law, becomes a counterproductive exercise. Because it means that we're entering into the realm of then having this legal argument over and over, a legal argument that's being settled not as a matter of legal scholars or some sort of legal adjudication, because the ICJ, the UN Security Council, and all of these other tribunals have affirmed that occupation law applies as a matter of outright taking or ceding these territories in peacemaking. For better or for worse, is contingent on what the Palestinian leadership does, and specifically exercising greater political resolve and ingenuity. Unfortunately, we don't have many indicators for hope on that count, as the Palestine delegation right now is preparing for its meeting with Trump, and Abbas has said that he thinks that statehood is actually going to be possible. So we're getting the indication that they're going to continue business as usual. We also got that indication in the aftermath of what everyone considered was a big deal when the US abstained from vetoing UN Security Council 2334 and actually affirmed again the applicability of the Geneva Conventions. And yet, the Palestinian Authority didn't challenge the balance of power, stayed mum, shuttled to the peace conferences in Paris in mid-January 2015, and shuttled home upon its failure, and used none of these advancements in order to create the political momentum that would be necessary to reverse these outcomes. Thank you.
Generally speaking, keynotes do not have a question and answer period, but Noura is particularly generous. So she will take a few questions.
You didn't tell me that keynotes don't do it.
Okay,
Okay, no, yeah, I'd love
okay. You don't, but
No.
we just have until 5, so just a few questions or comments or whatever. So the floor is open.
Am I moderating? Can you moderate?
Moderate. Joel, please.
So that was very brilliant, Noura, as usual.
Thank you.
I would add one thing, which is outside of the area that you dealt with, so obviously you wouldn't. The 1967 war was an Israeli war of aggression. Everything that happened afterwards is illegal. So we don't say that often enough, that Israel attacked first, and that there was no imminent threat of an Arab attack, according to all the evidence of the Israeli High Command after the war. Of course, they said this not before.
So I think I would agree with you, except that the legal literature that's interrogating that has a completely different record on the issue. And in fact, the 1967 war becomes almost a canonical example of legitimate preemptive self-defense in a way that you use 1967 to explain when you can use preemptive use of force in comparison to Israel's attack on the Osirak nuclear reactor in Iraq in 1981, which was seen as preventive and illegal, as opposed to this, in this instance, Egypt withdrew the UN peacekeepers, had its soldiers along the Strait of Tiran, and so on and so forth, notwithstanding historiography, which tells us, and obviously you're a historian, so you're particularly keen about this, historiography demonstrates that the Johnson administration was negotiating a diplomatic back channel with Egypt and Israel, and Egypt was fully participating in. And other historiography that tells us that the withdrawal of the UN peacekeepers was not a step towards war with Israel, but because they wanted to withdraw some of the peacekeepers and only had the choice to withdraw all, but not some, and so withdrew all. But all of that doesn't matter if we're thinking about the present of the legal literature that continues to deal with this as a canonical example of legitimate preemptive defense, and one, by the way, that also impacts the way that we think about the U.S.'s war on Iraq in 2003, as well as how the U.S. has used extrajudicial assassinations, better known as targeted killings, which is based on the same premise of attacking an assailant before there's an obvious armed attack, and you just know that they're going to attack, but you don't know when and you don't know how. And so that same logic becomes part of the Bush administration's 2006 national security strategy, where preemptive self-defense is what is established here in law, becomes established as a framework and as a model for the rest of the world. So when I'm saying that these things, that what Israel is doing here is not an outlier, it's not just, and this is something that I've been thinking about, it's not just that this is a series of aberrations, Israel did not comply with the law. They're not saying that. They're creating an exceptional model that becomes controlling upon anything that can have a similar fact pattern, except, as we know, that because it's sui generis, obviously there won't be many similar fact patterns. But the implications are global.
So that's why I'm saying we should argue about.
We should argue that.
About that it's a war of aggression. We have the evidence to prove it. It's a war
Well,
of aggression.
unfortunately, Egypt and Jordan didn't make that argument fervently enough when they agreed to the resolution. So also, what becomes the law is how the politics shape that outcome. But I don't disagree.
I have a question. So among the many frustrating things about this whole thing is, what explains the ineffectiveness and total weakness of the Palestinian government?
Wow. Okay, so that's the keynote next week.
Yeah.
Wow. So I don't know what the short answer to that is. I'm going to try to give you a fumbled short answer to that, which is to say that, so the 1967 war marked another juncture, and Joel talked about this morning as well, which was the juncture where the Palestinians realized that the Arab governments were not going to save them, and take the helm of the PLO, specifically, where Palestinian, because the PLO was created by Egypt and the Arab League in 1964, and it's led by someone appointed, a Palestinian lawyer that's appointed by Nasser. But, so Palestinians don't take the helm of the organization until 1968. And I think Arafat becomes its chairman in 69. Is that right? Okay. And Arafat becomes its chairman in 69. So thereafter, that was the most remarkable achievement, that the PLO is able to establish itself as a national liberation movement in a context, frankly, where there's national liberation movements all over the world. I didn't read this, but I think at the time there were only, there might have been 55 states. We have 193 states today. At the time, there were only 55 states. All of the other states that come into being in those intervening decades are former colonies. And so for the PLO to be waging this armed resistance in this context made a lot of sense, to be waging an armed resistance struggle. What becomes obvious after 1973, however, the October 1973 war, is that there will be no conventional war with Israel when Egypt and Syria don't continue the war, but actually just fight it enough in order to create the negotiating leverage to revert their territories for themselves. And that begins to change the calculus and the compass of the PLO moving forward, where it decides, and primarily the moderate forces of the PLO, led by Yasser Arafat, decide to pursue a diplomatic course. And so are actually creating back channels with the United States. The main goal is to enter into the Geneva Peace Conference. Kissinger, who at the time is mostly concerned with ensuring U.S. interests, disaggregates the Arab-Israeli conflict so that there are actual peace agreements with each of the Arab states rather than as a whole, so that the Palestinians are left off. And the idea was that Kissinger would resolve the conflict with all the other Arab states and then impose a solution on the Palestinians, was just not interested in allowing the PLO to enter those negotiations, although the Palestinians were. And so that germ, that knowledge of knowing that there would be no conventional war. It was really interesting. I actually interviewed somebody from the PFLP at the time who didn't give up on warfare. And I asked this question, well, who was going to fight the war? If Egypt and Syria were clearly neutralized, who else was going to fight a conventional war? Because the only other countries that supported ongoing war were Iraq and Libya. And they weren't going to be a viable option just by the lack of proximity and distance. And anyway, that becomes the seed for the desire to enter onto the diplomatic track. Then several ensuing intervening circumstances, including the routing of the PLO from Beirut in 1982, and the rise of Hamas in 1987, and then also when Arafat supports Iraq in the Gulf War, that diminishes their coffers. That basically sets the stage for the PLO's weak negotiating position entering into the Oslo peace process, and explains the outcome of those documents, which thereafter have made the Palestinian leadership an extension of this occupation regime and completely incapacitated its ability to resist. Short answer.
She doesn't how to make Israel, I guess we didn't talk about the future, abide by international law. I mean, all of this to me is academic flaws because they've never respected international law.
Yeah.
And what do you think of the BDS movement when state after state are embracing even that this is illegal?
So again, I would say that I would not. So and here, this is difficult, right? Because on the one hand, I would say that the goal is not to make Israel abide by international law, because as far as Israel is concerned, it is abiding by the law. As far as Israel is concerned, it has created a framework where it's in compliance with the law. It's not outside of it, right? So our insistence that it abide by the law under the way that we're seeing it is exactly what the Palestinians and the PLO has tried to do in these several legal challenges, and exactly what's proven futile. Because the law itself is not going to determine the outcome. The contest is over. Who gets to determine what the law is?
It's using the land.
And Israel is determining what the law is, even though there's an international consensus that it's not right, that legally and analytically this doesn't hold water. So that's why at the end I was suggesting that rather than be concerned with the application, and I look as somebody who does, as a practitioner, right? I do engage in this, but I engage in it very cynically. And part of my engagement in trying to pressure Israel to apply the law in the UN treaty-making bodies, for example, with the diplomatic missions in New York and so on and so forth, is precisely what led me to the academy. Because there is something to study that this all becomes performative. And the performance of trying to implement the law actually enables the continuation of these otherwise legal fictions. To then change the meaning of the law is to recalibrate the balance of power. So the question is, how do we recalibrate the balance of power? Palestinian leadership is not willing to do that. We see that very clearly. But BDS, as you mentioned, is one tactic that is able to leverage and curry some power. It's not enough, but the fact that it creates, it basically transcends governmental intransigence on this issue and mobilizes a politics of delegitimization that I think is creating pressure that works to at least approximate some grappling with the balance of power that none of these other discussions have done adequately.
Yes, please.
First, a few linguistic points, if I may. I think in linguistics, all is a quantifier, and it's hard to deal with. Chomsky found in a famous incident. Secondly, the translation into French, des territoires, would actually in fact mean all the territories. If you say des territoires in the abstract, it's territories, but actually I wonder if there was something of a row. Yeah, that if you're saying there was drawing des territoires occupés, it would in fact be all the territories. So I wonder if there was a row going on between the English and French about which was the major language of diplomacy. Now you can hear from my accent, we've been dealing with the English for a long time. And we assume that everything that comes out of them is self-serving garbage. And that actually the Americans will go on board with them because they have a huge inferiority complex. And that's it, for example, I will get on to the question in a second. For example, the Good Friday Agreement in Ireland, we gave up all our territory. We gave up the whole island. And the whole idea, the IRA just wanted their people out of prison, and now they've basically suspended the Good Friday Agreement indefinitely because enough time has passed. But the issue then is this, I mean, do you really believe that there is any legal way out of the quandary that you're in at the moment? Is there any possibility that some moral force will come in and restore justice there?
No. The short answer, and I hope it becomes clear in my presentation and later in the book, is no. I don't have any faith in the law. You know, the law doesn't guarantee a direction, and I think that's part of, and it depends, but I approach the law critically. I think that's, and this is part of a rich literature about what the law is and what it's supposed to be, My feeling is that the law doesn't ensure a particular direction, that it doesn't have this normative, bending towards the arc of justice. What the law does it ensures movement. It ensures some movement because it will create controversy. And it's that controversy which, when we use the law, when adversaries are using the law against one another, they're trying to determine what direction it's going to move us in. And so that the law in and of itself, you can't just rely on it. Obviously, the words themselves aren't going to determine that outcome. It's not predetermined. And no other field, I think, is more indicative of that than human rights. The settlers are waging, the 600,000 settlers, are waging a human rights campaign because they feel their human rights are being violated. And that's precisely because they're not using the law incorrectly, they're using it correctly. It's the indeterminacy of law that allows them to use that to assert they should not be removed from their home. They should not have their properties taken away from them. They should have the right to education where they want to study. And so they're waging that movement. So no, I don't have faith in the law. I did show this slide specifically for the reason that you mentioned, that if you go back into the record itself, that the record demonstrates what the meaning of this was, right? That the historical record is clear. It doesn't necessarily matter. And what's really interesting is that in the legal literature, there's still a debate about this. I think last year, a new article by a professor at Northwestern, Eugene Kantorovich, who is slated to be what people, everyone's like, okay. He actually lives in a Jerusalem settlement. And he's slated and has the reputation of taking the mantle of Alan Dershowitz when he leaves Harvard, of continuing. But Kantorovich published an article last year that basically makes a new argument that compares the language of 242 to all other resolutions mandating withdrawal from territory to demonstrate that this is different than all those other resolutions. Therefore, withdrawal wasn't the intended outcome. And you can do that with the law. You can do that with the law. If they're just comparing text of the law rather than going into this record, and so on and so forth. So.
Hi, thanks again for talking. I just had a question as to like the present and the future, like kind of similar to his, like what do you think is possible with reconciliation? The fact of the matter is that these two groups are living there, and what do you think the future would look like, and what do you think ideally, and how could we possibly reach that ideal?
So I'll tell you in 5 minutes. We're gonna fix this. We're gonna be free. So this is different. So what I'm sharing with you here is just, how else can we understand what's going on today if we understood what the law had to do with it? Remember what I said? If the law talk. So this is what we understand now. And so it should possibly at least inform us of whether or not we should use the law, and if so, how we should use the law, right? So that's one. Two, I think your question is asking something much more general. I'm going to answer that as a human being, not with an academic hat on, which is to say, I'm an optimist. I believe in freedom for all people. I think that we have the potential to all be free. I think that freedom that we can experience can be mutually beneficial and not a sum-zero equation. And unfortunately, the way that so many of these freedom struggles are being fought is being fought in a zero-sum equation or against the logic of a zero-sum equation, that only one of us can survive. And so I do think that there is a future. What that horizon looks like is about our ingenuity of what kind of societies we're willing to live in. And we don't have to look to Palestine to think about what that should look like or how it will look like. We can look here in the United States, where we're still dealing with the legacies of settler colonialism, where it's an ongoing process, I think most blatantly demonstrated, for example, at the Standing Rock, the Dakota Access Pipeline. I think that's visibly demonstrative, even though there's other things that make it visibly demonstrative to us every day in the form of broken treaties, sovereignty that we haven't recognized, genocide that we've never recognized. If you go to the Native American Museum, the death of Native Americans is attributed to war, and not to a campaign of annihilation, for example. If you think about, for example, the way that we dealt with black communities in the United States, and the fact that to the present, we have not been able to achieve even a state of acknowledgement of the unfreedom of black communities in the United States and the ongoing legacies of slavery and Jim Crow that manifest themselves in the prison system, in the forms of mass incarceration, in the form of deprivation and ghettoization, right? And we still have conversations around this that equivocate between, for example, the taking of black lives and the destruction of windows at CVS. What is that about? And what is that telling us when Donald Trump assumes office and removes the page for civil rights and creates a new page? He's taken it down since then, but creates a new page about defense of our law enforcement. So that these ideas, so these conflicts that we're dealing with here are ultimately about what potential do we have to actually figure out ways where our freedom is morally or is mutually reinforcing one another. What does that look like? And I think that even if we think about what it would look like here, would help us answer those questions as well.